Hello, and thank you for watching. My name is Bradford Roberts, Principal Broker, Founder, and Owner of TR Realty in the Las Vegas area. After watching this video, please be sure to like it as well as subscribe to our YouTube channel. Download the pertinent handouts for this video by clicking the link in the comments below. Now let's get started. This video is entitled Class 4 Seller Excellence. This segment is entitled Seller Paperwork. Now I'm about to give you a list of paperwork that you need to bring on a listing appointment. You would be prudent to write this down. This is a frequent question I get from my associates. What paperwork do I need to prepare for a listing appointment? So here is the list. You need to bring the tax records, the duties owed, the residential disclosure guide, the TR Realty seller's disclosure, your CMA including comps, consent to act, seller's real property disclosure, lead-based paint disclosure, supplemental property information, the exclusive right listing agreement, the residential data form, and the buyer brokerage agreement. One more time from the top. Tax records, duties owed, residential disclosure guide, TR Realty seller's disclosure, CMA including comps, consent to act, SRPD, lead-based paint disclosure, supplemental property information, ER listing agreement, residential data form, and the buyer brokerage agreement. Let us begin this segment by going directly to the TR Realty seller's disclosure. The tax records are self-explanatory and you can download those from the county's website. The duties owed and the residential disclosure guide are covered in my Class 3 video series, Let Us Go to the TR Realty seller's disclosure. And anytime we call a document the TR Realty this or that, it means it's our own creation. You're not going to find that in Transaction Desk. You're going to find that on the password protected page of our own website, or you can also find it once you log in to Broker Mint. Let's get that handout in front of us now and go through it together. The seller's disclosure says, this document shall serve as a list of important disclosures to you, our customer. However, this is not intended to be inclusive or exhaustive. TR Realty believes these disclosures are important while making a decision to sell real estate. This document does not obligate you in any way. Rather, TR Realty believes you have the right to be informed. Paragraph 1 talks about the right to legal counsel. You always have the right to consult with an attorney of your own choosing and at your own expense. So paragraph 1 is relaying the message to the customer that he always has the right to consult with legal counsel before, during, or after a transaction at any point. And there's nothing that a real estate licensee can ever do or say to dissuade someone from being represented by proper legal counsel. Paragraph 2 talks about the statute of frauds. Basically, for something to be enforceable, it has to be in writing. And that's why, even though in the state of Nevada verbal contracts are legal, in order to enforce those, they would have to be in writing. So therefore, the Las Vegas Realtor Association tells us all contracts must be in writing. And of course, that is TR Realty company policy as well. Paragraph 3 talks about effective contracts. Sellers are under no obligation, legal or otherwise, to entertain offers in the order in which they are received. Sellers control what, if anything, they decide to do when presented with an offer from a buyer, and they may opt to hold an offer, possibly along with others, until such time as they're ready to make a decision. Sellers may accept, reject, or counteroffer, but they're under no obligation to even respond. It is also possible several offers may be presented to the sellers, including offers by other TR Realty associates, until you have received in your possession a fully effective contract, which means signed by all parties and delivered to all parties. There is not yet a binding contract. So signing a contract and leaving it on your kitchen counter is not going to help you. It does not constitute an effective contract. Paragraph 4 Any fees paid for appraisal, inspection, certification, resale packages, and other costs associated with sale of a property may not be refundable. In no event shall TR Realty or its associates be responsible for these fees if a sale fails to close escrow. Of course, there are costs and there are risks with involving yourself in a real estate transaction. Paragraph 5 talks about fair housing. As many of my viewers know by now, TR Realty is absolutely adamant about enforcing fair housing laws and amendments. There is absolutely no hint of discrimination of any kind in this company, or I'm going to go bowling with somebody's head. I am very, very strict and very adamant about adhering to fair housing. Paragraph number 6 is what we call generically a relationship disclosure, which here in Nevada we call the duties owed. Nevada law requires a written disclosure entitled Duties Owed by a Nevada Real Estate Licensee to be provided to you prior to entering into an agreement. So therefore, the duties owed is always the first document that we do in real estate, whether it's today's video, which is the seller's class, or something that we talked about in the video series class 3, the buyer's class. We always do the duties owed first. And that's why I recommend when we send a listing package to our seller that we actually send the duties owed first. We wait for that to be signed, and of course by electronic signature it will automatically date and timestamp that. And then when we receive that back from our seller, then we go ahead and we send the rest of the listing package. That way always the duties owed has been dated and timed before any other document in our file, which, by the way, is the Nevada Real Estate Division's legal requirement. Moving on to paragraph 7, it talks about the vendor disclosure, that if we recommend any vendor to our seller, they're under no obligation to utilize that vendor's services. They're free to go outside and choose any company they wish. Paragraph 8 is a bit of a lengthy paragraph, and as you can see, there's actually 2 sets of initials that we require from our sellers, and that is because fraud is such a big deal here in Nevada. We talk about cyber criminals, how they target emails, etc., and wiring instructions and that sort of thing. So it's a very important paragraph that we have here, and it acts as a bit of a prophylactic for us as real estate professionals. Paragraph 9 talks about the fact that sellers are required to disclose any known material defects that they are aware of. Paragraph 10 talks about hazardous substances. Of course, there are many potentially hazardous substances on a piece of real estate. Paragraph 11 talks about mold, how we are not trained inspectors. We don't know and cannot differentiate between harmless mold and harmful mold. Paragraph 12 talks about inclusions and exclusions, that what is in MLS is not legally binding. The only thing that is going to prevail is what the agents actually had the intelligence to put in that purchase and sale agreement. What we talk about verbally is not going to work. What we see in an SRPD is not going to work. What we see in MLS is not going to work. It is the purchase and sale agreement that will prevail in all cases. Paragraph 13 talks about inspections. We are not licensed inspectors. Buyers typically arrange to have inspections, and as a seller, you may even wish to consider having an inspection prior to putting your property on the market. Of course, that is not required. Paragraph 14 talks about closing costs. The sale of real estate includes several costs and responsibilities. You might incur costs for title insurance, appraisal surveys, and it goes on. And then it gets to a very important part, which is our processing fee. If you have watched my video series, Class 1, specifically the video that talks about processing fees, then you already know that TR Realty, like almost every other company in Southern Nevada, charges a processing fee to our customers. And here at TR Realty, we allow our agents to change that fee accordingly. Sometimes there are cases you may wish to increase that fee. Those might be cases, as an example, where you're spending money on staging, just to give you one idea. Or you may wish to reduce that fee or completely waive that fee for a repeat customer, or perhaps for the sale of a very expensive property. So we at TR Realty are going to collect a $299 processing fee in a residential transaction, $399 in a commercial transaction, and that may or may not be what you wish to charge to your customer. But if you charge more or less, then the commission upon sale will be adjusted accordingly. And processing fees are not collected from the customer unless and until we have successful close of escrow. And then halfway down page 3, it says, you hereby acknowledge your TR Realty associate has explained these disclosures to you. Should you want additional assistance understanding any part of this disclosure, please ask your TR Realty associate or seek assistance from an independent source. Your signature below indicates you have read and understand this document and you acknowledge receipt of it. Please keep a copy of this disclosure for your records. And you can see there signature and date lines. It would be a great idea if we could put the time in there as well. And please don't forget the initials all the way down the bottom of every page. So that is the TR Realty seller's disclosure. The next one on my list of paperwork that you need to prepare and bring on a listing appointment is the CMA. And we covered that here in Class 4 in my video segment on setting the price. So let us move ahead to the next one on the list, which is the consent to act. Please get that out in front of you. The consent to act form is incredibly important, and Nevada real estate license law is very, very strict in this regard. Now, some states do not allow the concept of dual agency at all. Dual agency, which actually we now call in Nevada multiple representation. Dual agency is when one single licensee is representing the buyer and the seller, or the lessor and the lessee in the same transaction. So that is legal in the state of Nevada. At least it's legal as of the filming of this video. We'll see what the future brings. And even though it's legal, there are brokers in this area who prohibit that practice. They will not allow a licensee to represent both sides in a transaction. At TR Realty, we do allow that. But yellow flag, we do want you to exercise extreme caution. We want to make sure that duties owed is done on both sides, including the choice of may. You may represent more than one party. And of course, very importantly, in a multiple representation situation, we want to make sure that we do a consent to act. This form does not constitute a contract for services nor an agreement to pay compensation. Very important headline there at the top of this form. When it comes to the consent to act form, the reason that I'm recommending we do this as part of our listing paperwork is because we want the right to be able to represent a buyer should a buyer come along at any time in the future. And if we do this now, we are getting the seller's consent to represent a buyer so that we don't have to go back later. And perhaps your seller is busy, perhaps your seller is out of town, and it might be difficult to obtain the consent at that point. So this has always been a recommendation of mine to make this part of your listing appointment, to get it signed and to get it into your file now. There's another reason that I recommend we do the consent to act right up front as part of our listing paperwork. And that's because it's always been my opinion that should a real estate agent do an open house and a prospective buyer walks in who is unrepresented by their own agent, in my opinion, my interpretation of Nevada real estate license law, you should have a consent to act before you even tour that buyer around the property. I don't think I'm alone in my interpretation and my opinion here. So that is a second good reason why I think we should have the consent to act already in our file right upon taking the listing. So let's take a further look at this form. It says, description of transaction. The real estate transaction is the sale and purchase or the lease of some property. We need to make a choice there if we're working with buyers and sellers, or if we're working with lessors and lessees, and we need to fill in the property address. It says, in Nevada, a real estate licensee may act for more than one party in a real estate transaction. However, before the licensee does so, he or she must obtain the written consent of each party. This form is that consent. Before you consent to having a licensee represent both yourself and the other party, you should read this form and understand it. And there's a section where it says the licensee in this real estate transaction is, and that's where you would fill in your name as it appears on your license. Whose license number is, and of course that would be your license number, and who is affiliated with TR Realty. Then we have lines for the seller or landlord's name and the buyer or the tenant's name. If you're doing this form, as I'm recommending, as part of your listing appointment, you don't yet have a buyer or a tenant. So that's going to remain blank for the time being. But the seller's name is going to be filled in there. And I'd like to point out something interesting to you right here in this section of the consent to act. If you look at this form carefully and you compare it to another required form, which is the duties owed, you're going to see a requirement for your name, your license number, your company, principals' names, etc. But there's one piece of information that seems to be missing from the consent to act. Can anyone see what that is? It's actually the broker's name. Notice that there is no place on this form for the broker's name, unlike the duties owed where the broker's name is required. Some of you might be thinking that's an oversight, but actually I'd like to explain to you why that is. Some states that allow dual agency will have the law that dual agency applies to the brokerage. In other words, if one licensee working for the broker represents the buyer and a different licensee working for the same broker represents the seller, some states, not Nevada, some states would call that dual agency. However, in Nevada, dual agency is specific to the licensee, not to the broker. Therefore, the broker's name does not appear and is not required to be on that consent to act form. And going further on the form, it talks about a potential conflict of interest, disclosure of confidential information, the duties of the licensee. It also states clearly that the parties are under no obligation, no requirement to consent to the multiple representation whatsoever. And down the bottom of the form, there are places for the parties to sign, date, and time as well. So this is part of the listing paperwork. Get it done, get it in your file, and then if you come across a buyer on a moment's notice, maybe even at an open house, you'll be able to show that property legally in full compliance with the law without worrying about having to seek out the seller for his signature as well. So that is the consent to act form. Let me remind you once again, you are allowed to represent both parties as per Nevada law and also as per our company policy here. You can never reveal either side's motivation. You cannot favor one side over the other. You must represent both sides equally, honestly, and fairly. The next thing that I'd like to talk about here is the disclosure of material defects. So most of us know that Nevada law does require a seller to disclose known material defects. Let's look at that sentence. Known, first of all, because the seller is not expected to disclose something that he doesn't know, something that is latent, as an example. Maybe there's moisture inside a wall. If the seller has no knowledge of that, he's not required to disclose it. He only discloses known defects, and he only discloses known material defects, meaning that cosmetic defects are not required to be disclosed. And in my Class 2 video series, Real Estate Behind the Scenes, in the inspection segment, we do talk about the differences between material and cosmetic defects. So Nevada law requires a disclosure of known material defects, and it does so at least 10 days before the close of escrow. They don't have to be disclosed up front. They're required to be disclosed a minimum of 10 days before close of escrow. I'd like to bring your attention to the vehicle that we use to disclose those defects. That is known as an SRPD, Seller's Real Property Disclosure Form. Please go ahead and get that in front of you now. So let's go through this SRPD together because it is a really, really important form that we use in real estate. It says, in accordance with Nevada law, a seller of residential real property in Nevada must disclose any and all known conditions and aspects of the property which materially affect the value or use of residential property in an adverse manner. Adverse manner, of course, meaning in a negative way. It says we fill in the date, we fill in the property address, and then there's a question that the seller needs to answer for himself. Do you currently occupy, or have you ever occupied this property? It's a yes or no question, and the seller needs to fill that out, make that choice in the best way that he feels. We're not allowed to coach him or advise him on that. It says, effective October 1 of 2011, a purchaser may not waive the requirement to provide this form, and a seller may not require a purchaser to waive this form. And then there are some boxes that the seller can check depending on the type of seller he is. Is he a bank or a financial institution? Is he an asset management company? Is he an owner-occupier or something else? Something else could be an investor, something else could be a trustee, but again, he needs to fill this out as he deems appropriate. It goes on to talk about the purpose of this statement. It says, this statement is a disclosure of the condition of the property in compliance with the SRPD Act of January 1, 1996. The statement is a disclosure of the condition and information concerning the property known by the seller, which materially affects the value of the property. Unless otherwise advised, the seller does not possess any expertise in construction, architecture, engineering, or any other specific area related to the construction or condition of the improvements on the property or the land. Also, unless otherwise advised, the seller has not conducted any inspection of generally inaccessible areas such as the foundation or the roof. This statement is not a warranty of any kind by the seller or by any agent representing the seller in this transaction, and is not a substitute for any inspections or warranties the buyer may wish to obtain. Systems and appliances addressed on this form by the seller are not part of the contractual agreement as to the inclusion of any system or appliance as part of the binding agreement. Wow, that last sentence is crazy, isn't it? So poorly written. I want to make sure you all understand exactly what that sentence means. Long time ago, there's actually a lawsuit in Nevada where a seller filled out an SRPD and indicated that certain appliances, certain systems were working or not working on the SRPD. When the SRPD was conveyed to the buyer interpreted that as meaning that those particular appliances or systems were actually included in the sale when in fact they were not. So, what that sentence means in English is just because the seller indicates, yes, the dishwasher is working or the refrigerator is working or the washer is working, does not mean those appliances are necessarily included in the sale. As I told you earlier, the only thing that will prevail is the purchase and sale agreement. So the seller can feel free to fill out this SRPD in its entirety without having to worry about what's actually included in the sale of the property. The document continues. Instructions to the seller. Answer all questions. It doesn't say some, it doesn't say most. Answer all questions, because we don't want a transaction where the seller fails to complete the SRPD. A partially completed SRPD is basically worthless. And by the way, it would really cause the seller a lot of trouble in the future if he fails to complete the SRPD. Number 2 says, report known conditions affecting the property. 3 says, attach additional pages with your signature if additional space is required. 4 says, complete this form yourself. And let me pause for a moment to say a real estate licensee should never help the seller with this form and never fill this form out for the seller unless the licensee is the seller. This is one of the very few forms in real estate that we require the seller to fill out by him or herself without any assistance or guidance from the real estate professional at all. It goes on to say, if some items do not apply to your property, check NA, which means not applicable. So if we check NA somewhere, it means that that particular appliance or that particular feature of the home is not there. It goes on to say, effective 1/1 of 96, failure to provide a purchaser with a signed disclosure statement will enable the purchaser to terminate an otherwise binding purchase agreement and seek other remedies as provided by the law. I know a lot of real estate agents think the SRPD protects the buyer, but the reality is that it protects the seller. I'm going to circle back to that point shortly. The next thing on this form says, systems appliances. Are you aware of any problems and/or defects with any of the following? Listen to the question. Are you aware of any problems? So that is the question that we are answering, yes, no, or not applicable here. And every one of these choices needs to be addressed. Electrical, plumbing, sewer, septic, on and on and on. And as you can see below the boxes, it says, any yes must be fully explained on page 3. So any yes should trigger a red flag in the mind of the buyer. And down the bottom of that page, just like every other page, there are places for the seller's initials. Moving on to the second page of the SRPD, now we have a different layout. We have questions that also can be answered yes or no, and in some cases, there's a third box where it says NA as well. I'd like you to bring your attention to a couple of important ones here, specifically starting with paragraph 1, section D, where it says, whether the property is or has been the subject of a claim governed by Nevada law, which is construction defects. So this is a really important question. This can actually affect a buyer's financing as well. In some cases, if there's open litigation against a builder, financing might not be available to that buyer at all. That is a major red flag to a lender. There could be major problems. There could be financial problems, construction problems. Who knows what could be going on in the community. I'd also like to bring your attention all the way down to numbers 14 and 15 on this page that talk about the conservation easement and the solar panels. We did talk about the conservation easement in my video series class 2, and we did talk about it again in class 3. The conservation easement, in case you have not yet seen those video segments, is the Southern Nevada Water Authority's buyout program. And Southern Nevada Water Authority will pay a homeowner a price per square foot to remove water features on their property, such as grass, things that consume water. And the SNWA will pay a fee to the seller, but it creates an easement on the deed that actually lasts for 30 years. And it rides with the deed. So, in the case that somebody takes money from the SNWA to remove water features, and then they sell the property, and the next buyer decides that he wants to put grass back on that property, actually, he would be liable to the SNWA to repay that money, even though he wasn't the person who got it. And also, just as a reminder, even if that subsequent owner is willing to repay that money to the SNWA, that does not mean the city or the homeowners association would even allow it. So that is a bit of a minefield for us, hence the requirement to disclose it. And 15 is about the solar panels. Now, TR Realty is a green certified company. I live a green lifestyle. I'm all about that. And I know a lot of homeowners in Southern Nevada have tried to do the right thing by having solar panels installed on their property to either reduce or completely eliminate the need for being on the electrical grid. Great concept, right? However, we did have some predatory companies come into our marketplace and caused homeowners to either sign very expensive purchase agreements that they were paying in installments, in some cases with exorbitant interest rates, or to sign very lengthy and costly lease agreements for those solar panels. In both of those cases, whether those solar panels were purchased on installments or leased, those agreements will transfer to the incoming buyer. And not only can that affect someone's bottom line when it comes to the cost of owning that property, but it also is calculated into the debt to income ratio and can affect their ability to get financing on the property. So 14 and 15, conservation easement and solar panels, these are two really, really important things that we need the seller to disclose. Moving on to page 3 of the SRPD, we referred to this page a couple of minutes ago where it said on page 1, any yeses need to be explained on page 3. And as you can see, page 3 is basically a blank space. It is a space where the seller can explain anything he answered yes to on the rest of the SRPD. Don't forget the initials down the bottom of the page. Let's go on to page 4 of this SRPD, where there are a couple of things I'd like to bring to your attention. About 10% of the way down the page, where it says item number 1, there is the definition of the word defect. And the reason I point this out is because when you're with your seller, a lot of times the seller will ask you, is this a defect? Is this something that I need to disclose? Well, we cannot be the person who determines whether something is disclosed. So we would bring the seller's attention to this line, and this is the definition of a defect. Defect means a condition that materially affects the value or use of residential property in an adverse manner. But I think, definition notwithstanding, I think the question that a seller needs to ask himself is this something that I would like to know if I were the buyer on this property? You know, the golden rule, right? Treat others as you would like to be treated. So I think when it comes to disclosure, we always want to err on the side of disclosure. We want to give that buyer every benefit of the doubt when it comes to knowing things about the property he's buying. Let's go about 40% of the way down the page, where it says that the disclosures set forth in the form are made by the seller and not by his agent. Another reason that I told you a few minutes ago, this cannot be filled out by the agent or assisted by the agent in any way. The seller needs to fill this out by himself. Halfway down the page it says completion and service of disclosure form before conveyance of property. And if you drop down to 1A, it says at least 10 days before residential property is conveyed to a purchaser. Then it says the seller shall complete a disclosure form regarding the residential property, and if after service of the completed disclosure form but before conveyance of the property to the purchaser, the seller or the seller's agent discovers a new or worsened defect, it must be disclosed. It is that reason that some listing agents choose not to get an SRPD at the time of taking the listing, because they know there's a possibility they may have to update it later. BS. We need to get that SRPD right up front. We need to have it available. Some savvy buyer's agents will ask for the SRPD before they even write an offer. But we do need to be cognizant of the fact that if there's a new defect or a defect that we already disclosed becomes worse, we will need to update this SRPD before the conveyance of the property. I want to bring your attention about 80% of the way down the page to where it says subsection 1 does not apply to a sale or intended sale of residential property by foreclosure between co-owners of the property, which is the first sale, meaning new construction, or for a person who takes temporary possession. All of those things would be exclusions for those who would be exempt from providing an SRPD. I do cover that in more detail in my video series, Class 3, where we talk about exemptions to the SRPD. Don't forget the initials down the bottom of the page. And moving on to page 5 of the SRPD, there's a couple of things I'd like to point out here. About 25% of the way down the page, where it says Nevada law does not require a seller to disclose a defect in residential property of which he is not aware. So it's not a warranty, it's not a guarantee, it's not intended to replace an inspection. About an inch below that, it says, if a seller or the seller's agent fails to serve a completed disclosure form in accordance with the requirements of Nevada law, the purchaser may, at any time before the conveyance of the property to the purchaser, rescind the agreement to purchase the property without any penalty. What that means is cancel the purchase and sale agreement and get his EMD back. I'd like to bring your attention about halfway down page 5, where it talks about if a seller conveys residential property to a purchaser without complying with the requirements of Nevada law or otherwise providing the purchaser or the purchaser's agent with written notice of all defects in the property, of which the cost of repair, etc. What this is talking about is the fact that the buyer would have the right to recover 3 times the cost of that repair or replacement, plus the right to legal fees as well. So that's why I mentioned earlier, it's really, really important to protect the seller, that the SRPD is filled out on time, absolutely accurately and completely. I know some sellers think that if they disclose something, it might scare the buyer away. I would rather scare a buyer away than be facing a lawsuit for treble damages plus legal fees, wouldn't you? And I'd like to bring your attention about 80% of the way down page 5 to the bold capital letters where it says, seller has duty to disclose to buyer as new defects are discovered and or known defects become worse. I think I've already touched on that. And then you see a place for the sellers to sign and date. Please get them to write in the time as well. And subsequent to that, the buyer needs to sign, date, and time this SRPD as well. This is a really, really important form. We require it on our closing checklist, and my associates must learn to do it correctly. Few things that I want to point out or even reiterate on this SRPD. One is that any unanswered item on this SRPD, any unanswered item enables the buyer to cancel the contract. I also want to talk about death and the disclosure of death. You know, California is very different than Nevada in this regard, because in Nevada, real estate licensees are not required to disclose death on a property unless the death was caused by the property itself. So if the roof fell down and hit somebody on the head, or if somebody fell through the stairway, or somebody died of lead-based paint poisoning on the property, yes, those things have to be disclosed. But if the death had nothing to do, was not caused by the property in any way, the death need not be disclosed. I also get this question, what about past problems? What about an issue that existed but was remediated? Does that need to be disclosed? Yes, it needs to be disclosed. Keep in mind, we always err on the side of disclosure. Also, we talked about exemptions. No seller, not even a bank, can ask a buyer to waive this SRPD. And to refresh your memory from my Class 3 video series, there are some exemptions. New construction is an exemption. There's no SRPD in new construction. Co-owners are exempt. Trustees are exempt. Close family members within the third degree of consanguinity are also exempt from having to complete an SRPD. And I also want to remind you of something that we talk about in Class 3, which is the buyer's class. If a buyer is ever forced to waive the SRPD and the seller is not exempt, folks, we must protect ourselves. This is a huge potential for liability right here. In Class 3, we talked about it. I'm repeating it right now. There's a form called Buyer's Acknowledgement and Release. The Buyer's Acknowledgement and Release must be effectuated by the buyer if the buyer has not received a completed SRPD. I hope I'm making myself clear right there. I also get asked, do we get an SRPD on a short sale? Absolutely. Who owns a short sale? Don't say the bank. The short sale is still owned by the seller, and therefore the SRPD is required. I also want to mention that we have a form available to us in Transaction Desk known as the Vacant Land Disclosure. The vacant land disclosure is what we would use if we were selling unimproved land. And unimproved means there's no structure of any kind. Not a house, not a garage, not a barn, not a shed, nothing on the land. It's just land. We actually don't use the SRPD. We use that vacant land disclosure instead. When you're listing an older home, you must provide a lead-based paint pamphlet to the buyer. Here in Southern Nevada, when we talk about an older home, we talk about something that was built before 1978. So the date of January 1st, 1978 is the point of delineation. Sometimes I get asked, well, what happens if the house was started in 1977, finished in 1978? So we need to follow the tax records on that. The tax records are not going to give you a range. The tax records are going to say an actual year. So if the tax records say 1977 or before, we need to deal with lead-based paint. If the tax records say 1978 or after, we do not. It is that simple. Don't make it any more complicated than that. When it comes to dealing with lead-based paint, there are two things that we need to deal with. One is the lead-based paint pamphlet. The other is the lead-based paint disclosure. The lead-based paint disclosure is included in our handouts today. So let's go ahead and get that disclosure in front of us. In fact, the official title at the top is Disclosure of Information on Lead-Based Paint and/or Lead-Based Paint Hazards. I'm surprised they fit all of that at the top. This form is pretty ugly, honestly, and confusing. It is one of the most frequently misunderstood forms, even though it is 1 page long. The way this thing has been laid out, in my opinion, makes it very, very confusing, and therefore there is a huge number of mistakes that we see on this form. Let me be very clear. When it comes to lead-based paint issues, we are talking about federal law. This is not something that we can get wrong. This is something that my compliance department is going to be absolutely adamant about getting it right. And that's why it's so important that we watch these videos and we follow along closely. We have the handouts in front of us and we go line by line together. Let me say it again. This document must be done correctly, so pay careful attention. It says at the top, lead warning statement. Every purchaser or any interest in residential real property on which a residential dwelling was built prior to 1978 is notified that such property may present exposure to lead from lead-based paint that may place young children at risk of developing lead poisoning. Lead poisoning in young children may produce permanent neurological damage, including learning disabilities, reduced IQ, behavioral problems, and impaired memory. Lead poisoning also poses a particular risk to pregnant women. The seller of any interest in residential real property is required to provide the buyer with any information on lead-based paint hazards from risk assessments or inspections in the seller's possession, and notify the buyer of any known lead-based paint hazards. A risk assessment or inspection for possible lead-based paint hazards is recommended prior to purchase. Let's break this down so we get it right every time. The first section says seller's disclosure. This document is going to volley around in a real estate transaction. But since the first section is the seller's disclosure, I am recommending that we do it at the time of taking a listing. That's why it's on my list. A, presence of lead-based paint and or lead-based paint hazards, check 1 or 2 below. Whenever you see the word, you see the word or, it's not both, it's not neither. Or means we need to make a selection. A1 says known lead-based paint and or lead-based paint hazards are present in the housing. Or A2 says seller has no knowledge of lead-based paint and or lead-based paint hazards in the housing. If the seller initials, and yes, I like initials, I don't like check marks or X's. If the seller initials that lead-based paint or hazards are present on that A1 line, then on the subsequent line he needs to explain exactly what is present. Or A2, he has no knowledge of lead-based paint or hazards. It can't be both. Think about it logically. You can't have knowledge and not have knowledge at the same time, although that pretty much describes our politicians, doesn't it? But if you think about it, it's we have knowledge or we don't have knowledge. 1 or 2 needs to be initialed. Can't be blank, can't be both. Then it goes on to ask the seller a second question, which is B. Records and reports available to the seller, check 1 or 2 below. Seller has provided the purchaser with all available records and reports pertaining to lead-based paint, or seller has no reports or records pertaining to lead-based paint. You can't provide something you don't have. So again, we're facing an or situation where the seller is going to initial B1 or the seller is going to initial B2. Can't be blank, can't be both. So there is the seller's disclosure section. Let me say it again. We're looking for the seller to initial one choice in A, one choice in B. Let's move on to the purchasers section. So now when a buyer is procured in the transaction, this lead-based paint disclosure would be conveyed to the buyer's agent, who now has to answer some questions of his own. C, purchaser has received copies of all information listed above. C would only be initialed if he received copies of information listed above. If the seller indicated in his section that he has no records, he has no reports, he has no information, how could the purchaser initial that he received it? So C is only when the seller has indicated there's something to provide and has provided it. D, purchaser has received the pamphlet, Protect Your Family from Lead in Your Home. That has to happen every time. D must be initialed by the buyer every time. Why? Because that lead-based paint pamphlet is a requirement as per federal law. So we cannot accept this lead-based paint disclosure unless D is initialed by the buyer. E, purchaser has, check 1 or 2 below, received a 10-day opportunity or mutually agreed upon period to conduct a risk assessment or inspection, or waived that opportunity. Well, another way of saying this is the due diligence period. So if we have an RPA in which the buyer has a due diligence period, then that's going to be choice E1, that the purchaser has in fact received an opportunity to check the property for lead-based paint. E2, where the purchaser has waived that, in my opinion, would be incredibly foolish. And that's the purchaser section. So to recap, C, only when the buyer has received information as stated in the seller section. D, always. E, we make a choice, 1 or 2, preferably number 1. Now the document volleys again for the agent's acknowledgement. Let's look at line F. Agent has informed the seller of the seller's obligation and is aware of his or her responsibility to ensure compliance. Agent has informed the seller. Which agent do you think is working with the seller? Obviously, we're talking about the listing agent, right? So on line F, we are looking for the listing agent to initial. Certification of accuracy. The following parties have reviewed the information above and certified to the best of their knowledge that the information they provided is true and accurate. And if you look down the bottom at the signature lines, you'll see 2 lines for sellers to sign and date, and hopefully they can add the time in there as well. You'll see 2 lines for purchasers to sign, date, and add the time. But then, very importantly, folks, you'll see 2 lines for agents to sign, date, and time. Why are there 2 lines for agents? It is because all licensees in a transaction, when the house was built before 1978, are equally liable for the lead-based paint disclosure and the provision of the lead-based paint pamphlet. Regardless of which side of the transaction you are on, all licensees are liable. And therefore, at TR Realty, we require both licensees to sign on the bottom of the lead-based paint disclosure. I hope that I have covered this document carefully and sufficiently for you. It is really, really important. Get it right, or my compliance department is going to send it back to you and reject it. And now I'd like to get to the supplemental property information handout. Please make sure you have that in front of you right now. The supplemental property information form is not a requirement as per law or anything like that, but I think as the listing agent in the transaction, this will really help you. And specifically, it will help you to have a more accurate picture of the seller's financial position, because as you well know, the seller's financial position can have an effect, a dramatic effect, on how the transaction actually occurs, right? So let's take a look at this form from the top. It says, seller is aware that certain issues may affect the sale of the above-mentioned property, the seller's ability to close escrow, and/or the buyer's ability to secure financing. In addition to any other disclosures required by law or contract, the seller represents the following information is complete and accurate as of the date below and agrees to notify the listing agent within 2 business days of a status change in any of the following. Paragraph 1 talks about missed payments. Very simply, it says seller currently is or is not current on all payments. I don't write that English, folks. That is a standard form from our Realtor Association. Seller currently is or is not current on all payments, mortgage notes, deeds of trust, etc. We would like to know that because even if we checked the recorder's website and we don't see a notice of default, we don't see a summons and complaint, we would still like to know if the seller is behind on his mortgage, because this transaction might turn into a short sale at some point. Paragraph 2 talks about foreclosure, litigation. Information regarding the foreclosure or litigation status of a property is available from the county recorder or court where the property is located. We just talked about that. And it goes on to talk about a notice of default and a summons and complaint. As you know by now, watching my videos, notice of default would be an intent to conduct a non-judicial foreclosure. Summons and complaint would be an intent to conduct a judicial foreclosure. So we want the seller to go ahead and indicate that. 2C is a notice of sale. Whoa, this one is really dangerous. If you have the seller do this supplemental property information form and the seller indicates on 2C that a notice of sale has been recorded against the property, you better come and see me right away, because probably what that means is this property is going to an auction sale in less than 30 days. Meaning, in less than 30 days, if we don't find a way to save it, this seller is going to be living under a bridge somewhere, okay? So if they fill out 2C, you better come and see your broker. D is a statement of litigation. The seller is or is not a party to any ongoing litigation. E is about probate. Probate is an issue that 20 years ago we didn't think about very much. Today it is coming on strong as the population ages, and as the population of Southern Nevada actually ages at 4 times the national rate. We are dealing with more and more probate transactions. We can list a property that's in probate with full disclosure. Obviously, we need the judge's approval to consummate the sale, and we need the buyer to accept the fact that this transaction could be delayed for a little while. I've seen probate cleared in 2 weeks. I've seen probate take a year. So just be aware that probate means we're going to spend a little more time, put a little more effort into the transaction. The judge has the right to interfere with the contract. Maybe I shouldn't say it that way, but the judge has the right to say, as an example, this price is too low or whatever, the terms are not right. He does have the right to come back and attempt to modify the contract. So that's why we have to disclose anything about probate. Paragraph 3 talks about bankruptcy. We need to know if the seller is in or was in bankruptcy, as it can affect the sale. If the property is currently being protected as per bankruptcy petition, we cannot sell the property. We can list it, but before we actually consummate a purchase and sale agreement and a conveyance of the property, that property would have to be released from the bankruptcy petition. There are perils to doing that. Definitely the seller would want to consult with an attorney at that point. Paragraph 4 talks about the super priority lien status, whether the seller is in default of any super priority lien payments, including and especially homeowners association or CIC dues or assessments. So I'm going to get into super priority liens more in my Class 6 video series, which is my short sale class. However, for the purposes of this form, I'd like to let you know that Nevada is unique and different, that we have enacted something called super priority lien status. Nevada is the only state that I know where first isn't first. So we actually have something called super priority lien status, which would put certain entities, such as a homeowners association, above a first lien holder, meaning that they would have the first right of foreclosure on the property. And actually, this is something that has been going through the courts in Nevada, might even go higher than Nevada courts at some point. But as of the filming of this video, if an entity such as an HOA filed a foreclosure against a property, the first lien could be completely expunged, wiped out completely. That doesn't sound like very good business for the lien holder. And it's a bit more complicated than that. The law used to say that entities had to opt in. Now it says they have the right to opt out. There are some changes there. I'm sorry, I know this is a bit complex. I don't want to spend a lot of time on this right now. We will do so in my Class 6 video series. But for right now, what we need to know is the seller defaulting on any HOA payments or other super priority lien payments. Paragraph number 5 is the solar panel issue that we talked about when we covered the SRPD. We're asking the seller here, does the property have solar panels installed? If so, are those solar panels leased or owned? Paragraph number 6, Southern Nevada Water Authority. We're asking the seller to state, yes, he's participated in the SNWA program, or no, he has not. And by the way, I should mention, because I do get the question, how would a buyer know about this? Typically, the buyer wouldn't get to see this. How would the buyer know? Well, there's 2 ways the buyer would know about that. One is the SRPD, but of course, that's assuming that the seller filled it out honestly. So the second and better way, in my opinion, is the preliminary title report. The preliminary title report, which I cover in my Class 2 video series, Title and Escrow segment, is where the title company is going to run a report within 10 days of opening escrow and going to provide that report to the buyer. That's where we would be able to see if a conservation easement was filed against the property. And lastly, paragraph 7, the parties have the right to consult with professionals of their choosing to get advice. And you can see the lines for sellers and buyers to date and sign below. Please get them to add the time on there as well. So that is a supplemental property information form. Not a requirement, not a legal requirement, but something that I highly encourage listing agents to make part of their listing paperwork. It's going to put you in a much more knowledgeable position so you can better serve the listing and better serve your client. I would like to thank you for watching this video. I hope it was informative for you. If you are licensed with another brokerage in Southern Nevada and would like to talk with me, please text me or visit our website. See you next time.